Hello everyone, welcome back to my channel. Don't forget to like, comment, and subscribe. Okay, today I will tell you about crew members are entitled to free medical care under maritime law. Under American maritime law, all vessel owners and operators have the legal obligation to provide free medical care for any crew member that is injured or becomes sick while he is working or is in the service of the ship. By the time of the case of Harder vs. Carden in 1823, this was already well-established law. Okay, what does this mean for the crew member working on a cruise ship? Well, it means that if a crew member suffers an accident on a cruise ship and becomes injured or sick, the company he works for cannot evade the responsibility to provide him free medical care by the simple expedient of sending him home. The company cannot legally abandon an injured or sick crew member. The obligation to provide free medical care to an injured or sick crew member is so strong that it doesn't matter if the crew member was negligent or had any fault in causing his maritime accident or sickness. The only legal requirement to receive free medical care is that the crew member be working at the time of his medical problem or that he be in the service of the ship. For example, if a crew member is injured or becomes sick while on shore leave, he is still entitled to free medical care. If a crew member is traveling from his home to the ship or from the ship to his home, he is entitled to free medical care. American courts have been so generous in interpreting the crew member's right to receive free medical care that in the famous case of Coistinen v. American Export Lines, a crew member was allowed to recover the medical expenses he incurred when he was injured by jumping out of the window of a house of prostitution. And then the next, what types of injuries or sickness entitled to crew member to receive free medical care? The injury or sickness doesn't need to be related to the crew member's work. It doesn't need to be caused by a maritime injury or other cruise ship incident. For example, a crew member is entitled to free medical care for a gallbladder attack, heart attack, and then diabetes, kidney stones, mental conditions, or any other medical treatment. Even when a pre-existing medical condition recurs, the crew member is still entitled to free medical care. The crew member's right to receive free medical care from the company is expected to work automatically without uncertainty or administrative delay or haggling. American courts have imposed a duty on the employer under maritime law to pay for the crew member's medical care irrespective of cause or fault and to resolve any doubt in favor of paying the crew member's medical expenses. And then the next, where am I entitled to receive my medical treatment? Well, the crew member is entitled to receive his emergency and non-emergency medical care aboard the ship, and at the nearest port depending upon of the severity of his injury or sickness. If the cargo or cruise ship injury or sickness renders the crew member unable to work, then, after the initial medical care is given, a doctor will determine if he is able to travel. If the crew member is able to travel, he will probably be sent home to receive his medical care. If the crew member is not able to travel, he will receive free medical care wherever he is at. And then the next, can the company send me to a third country to receive my medical care? In the last few years, many of the cruise companies negotiated with doctors and hospitals in poor countries to obtain cheap and low-quality medical care for their crew members. Instead of giving the medical care at the closest port or in the crew member's home country, they try to send the crew member to a third country for his medical care. This is not an accepted practice, and the crew members can and should refuse to go to a third country for medical care. And then the next, when does the company obligation to provide medical care end? The company's obligation to provide free medical care ends when the crew member has reached maximum medical improvement. And then the next, what does maximum medical improvement mean? Okay, maximum medical improvement means that, in the doctor's opinion, any additional medical treatment will not improve the crew member's medical condition. The next question, who determines when the crew member has reached maximum medical improvement? This is determined by the crew member's doctor. When the crew member's doctor writes a medical report saying that the crew member will not benefit from any additional medical care, the company's obligation to provide it ends. And then the next, can I challenge the doctor's opinion that I have reached maximum medical improvement? If the crew member disagrees with the doctor's opinion that he has reached maximum medical improvement, he can challenge the doctor's opinion. If the doctor would determine that the crew member has reached maximum medical improvement was selected by the company instead of the crew member, the crew member can get a different opinion from an equally qualified doctor and challenge the company doctor's opinion. If the crew member selected his own doctor, challenging his opinion is far more difficult, but it is still can be accomplished in some cases. And then the next, what can I accomplish by challenging the company's, what can I accomplish by challenging the company doctor's opinion as to maximum medical improvement? Well, a successful challenge to the company doctor's opinion will result in the company reopening the crew member's medical file and giving him any additional treatment that he may need, such as additional medication, additional medical testing, additional therapy, additional surgery, and etc. And the next, do I have to see the company doctor for a Jones Act claim? Well, if you suffered a workplace maritime injury, you don't have to see the company doctor for a Jones Act claim. You may need to consult the company doctor if your accident happens at sea. You may need to consult the company doctor if your accident happens at sea and they are your only immediate treatment opinion. However, as soon as you are able, you should consult a physician of your choosing. Your employer has no right to mandate or pressure you into seeing the company doctor. Likewise, they should not try to prevent you from seeking treatment from a provider you select. If you have not already visited a doctor not connected to the company, if you have not already visited a doctor not connected to company, do so immediately. It is important to seek treatment right away and follow your prescribed treatment plan. Okay, that's all for today. Thanks for watching. Don't forget to like, comment, and subscribe this channel. See you in the next video, and bye bye.